Hello, Leonard friends and viewers in general. You're welcome to this special chat with Chief Thompson Joseph Onomibo Okoko OONSANFCR. He is our special guest in this special edition of the MBA webinar series. As a matter of fact, you are aware that Chief does not need any introduction. But this particular event is actually designed to mark the 50th Golden Jubilee. In the course of reading your biography on Saturday, the 19th day of June 2020, when we actually, the MBA Warri branch, as a matter of fact, honored you on the 50th post call ceremony. We discovered something that you were a teacher at a particular point. Could you please tell us something about it?
Thank you. When I finished primary school, in those days in Warri, there were three chances open to you for work. If your father is a very wealthy man, then he can go and pay security to one of the market houses on both UAC and others, Kingsway and others. If your father is able to deposit £300, you can deposit £200, you can become a talent. And if he pays £100, deposit is security, not that it's private, it's not. Then you leave the job, they give it back to you. If you pay the father only for £100, then you can become office messenger.
Hmm.
That was the way that you can go into the commercial practice of the time. And this is actually to if your father is a produce merchant, bringing palm kernel and oil to Warri to sell to you, then you have the chance. I didn't have any of those chances.
Hmm.
The second one that's opened everybody into government was to join the police. To join the police. In those days, the local people, they will measure the chest, they measure the height. I have neither the height nor the chest. So that side was close to me. What then was open was teaching. If you go to local government and federal authorities to go and look for teaching jobs, you'll be asked to pay a bribe,
Hmm.
ranging between £3 and £5. And for me, going to pay bribe to get a job was not a viable proposition for me, even at that stage.
Hmm.
And so, those who are like me, who did not want that type of thing, resort to the mission schools. And the most popular mission school in Warri at that time was the Catholic schools. So I went to the Catholic mission and I was lucky to be recruited by Father Foley, an Irishman. So that's how I became a teacher.
These are very, very much revealing because, in the first place, it actually reminded me about how I started teaching in primary three. Somehow there was a problem with my enrolling. Then my parents were DSC workers. They had problem with the usual DSC problem, and there was no money to enroll myself and my elder brother. So by the rope custom, the older one will have to go first, then before the younger one. So that was how the study should go. So I had to go look for the money to give to them for me to. But they no, you have to wait. They let him go. So I somehow when my mom saw that I was tough on her, she had to take me to one teacher then, one proprietor of a school called Mr. Ede of Precious Primary School. That was how I started teaching. So, in fact, when I read that part in your biography, when they were also reading your biography, I got motivated. And I said, this interview is going to be a must for all to learn. Thank you, Chief. So, sir, again, still on your post, your pre-law practice job experience, we also discovered in the course of reading your biography that you were a post post driver, postmaster, something post driver or postmaster or
Okay,
whatever. We wanted the clarification,
okay.
from
Now,
that
the
perspective. Sir.
position was that I went into teaching as an untrained teacher. After 8 years in various schools, I passed the entrance to go to the Delta Provincial Teacher Training College and became a qualified teacher in the 10th year, 10th or 12th year, or something like that. So that was the position I held, and I continued teaching while I was reading, burning the midnight oil in my attempt to pass GCE because of the bitter experience I had as a student in the teacher training college at that time. I started to injustice and discipline that you don't deserve. So by 1964, I had got the GCE ordinary level. Then my friend, Professor Yomari, and I saw in a letter, in an envelope, brown envelope, a stamp, rubber stamp, one of us had been to the block before, but we saw it there. Said the letter from passport control office. In the middle, over the signature that it is partial. Then we saw that dispatched by Eddie Ikomi, who suspected that it's a man from this area. But we have never seen him. So we wrote to him. We saw your name in social place. Can you help us with passport forms? Eddie has never seen us before. None of us. Within 2 weeks, he sent 2 sets of passport forms to us. Told us what to do. And we filled the form, sent £1 postal order. In another 3 weeks, passport was sent to us. That was the time we decided to go to Lagos to try to trace it. And that was my first time in Lagos.
Don't worry.
So
finish it.
that was my first time in Lagos. I left there. We went to Lagos to see Eddie. We were speaking to Eddie. Asking Eddie that we're looking for one person called Eddie. The person was speaking, unknown to us, that the person we're speaking to is Eddie Ikomi himself. He asked us where we came from. We said we're from Sapele. When you look for Eddie Ikomi, say, I am Eddie Ikomi at that stage. That was how we marshaled our way through Eddie Ikomi, who then assisted us with school addresses in the UK, right to the schools, which we did. 1 month later, we got letters of admission. I remember the name of the school. It's a school called Tunic Sulphur College of Music. So we said we're going to study music. But I knew from the beginning that that is to give me entry into England and not to study music. So that was how we got to the UK. It was when we got to the UK the very day I got there, I got a job. Worked in one small warehouse for about 2 or 3 weeks. For about 2 or 3 weeks.
Don't worry.
Then I left there and joined the post office. So after writing GC exam, I now applied to Mount Pleasant Post Office. In Mount Pleasant, it's a parcel post office where they treat all their parcels all over the world. That was where I worked as a postman at first. 6 months later, they found that I worked hard. Worked very hard. So they sent me for training as a driver. So that was when I passed the driving test. That was when driver.
These are very interesting.
This is my British. The first one in red, issued 7th March 1966. So I drove until sometime the result of GC advance has come. And finally, we got admission. I got admission into Holborn College of Law at Red Lion Square in London. And that was how I resigned from the post office and went to the place. My time at the post office was quite remarkable. Normally, you will not be sent for driving school training until you completed 1 year. But in my own case, less than a year, less than 6 months, I was sent there because I worked hard. I didn't allow any time to be wasted. So that's how I got that thing.
That's very much interesting. It's part of what this program is designed to achieve.
So at the towards the end of 96, 1966, I got admission, resigned from the post office, and started my study of law.
So it depends. The job experience, the pre-law practice job experience actually influenced your thoughts about this law practice from what you have said so far.
Thank you. My experience as a teacher was very valuable to me. It made me inquisitive. I want to know the matter to the root. And then the behavior of people on the witness box is very crucial because you can lose a case or win a case by mere observance of the behavior of the witness box. We did the teacher training children behave.
Yes,
That gave me the background
educational psychology.
into considering how people behave when they are in different places. So to that extent, and to the creation of the spirit of investigating things to the bottom, I think my training as a teacher was crucial.
It is not surprising at all. In fact, the younger generation has so much. They have so much to learn from what you have said so far. What will you be right for based on your experience now as it relates to the teaching and how it affects your practice positively and all that, for you to recommend that it would be ideal that uh, for anybody to, before anybody will even think about going to the university to study anything, it would be ideal that person have a kind of teaching experience.
Um, I do not think it is necessary to make specific provision for teaching experience. First, we do not have enough qualified teachers in this country. Second, that type of background can be got from either the university or so. I understand that my friend's university, Babalola, when you go in, the first year you spent on general things. You embark on your course from your second year. I think that's a wonderful thing that Babalola done. And I think that's something that schools should try to emulate.
Okay.
And let me say this one. Babalola had almost the same background as myself. We were both teachers. I don't think he was a very rich teacher. Certainly I know I was not a rich teacher, but we were both teachers.
Yes.
Little things can satisfy us,
Yes.
can make us content. When your students' result come and they pass, that's a matter of joy and celebration.
Yes.
There's one point I left about Komi, who was about to get a passport. As soon as we got to the UK, we wrote back to tell him the situation in which we found ourselves there. I was earning £15 a month as a teacher. When I got to the UK, my salary was £12 10, 12 pounds 10 for a week
In the UK.
in the UK.
Okay, you were working.
The first job I took in the UK, I worked for a whole year plus before starting the full-time course. So we encouraged him, and by the end of the day, he himself joined us before December. We went in September. By December, he had joined us there.
Wow.
Very happy.
Wow.
He came back before us.
That's lovely.
And to think about what happened, I've not seen him since he came back, but we have talked on telephone many times. He became the general manager of Panapina World Transport. Later, I became a director and chairman of Panapina World Transport. But by the time I became a director, he had retired. So you see how God put people together.
This is very, very interesting and revealing.
So that's life.
Wow, that's lovely. In fact, I want to say this about the best time that we have actually had, with you, because I doubt a lot of lawyers have known this about you, and a lot of people have heard so much about Chief Okpoko, SAN, how he was able to climb to the top is a success story, but very few people know much about the other side, and that is what this program is designed to achieve.
Thank you.
So, Chief Sir, further, we understand that you, at a point, you got involved in politics with the Constituent Assembly uh, uh, initiative, which actually brought about, I think, the 1989 Constitution, and also to a great extent, even the 1999 Constitution, because from what we observed, the 1979 Constitution and the 1989 Constitution are more or less what we have in the 1999 Constitution. Yeah, tell us something about it.
Thank you. I was interested in politics, but never interested in partisan politics. I love my country.
Yes.
I love my community. I love my profession. I want to make it better. I contested the election on a non-party basis into the Western Road District Council.
And that is what is called the independent candidacy now.
I know there was no party at that time.
Okay.
It was thrown open. I contested in my home place and I won. Our council met at the Roro, and that was all that I did. When it became a matter of acrimony between Party A and Party B, of course, I was standing independent, and many of their disputes in my area were resolved at my distance. So that's the extent I went in politics. Constituent Assembly was a matter of delegate legislation, not open to party politics. But the delegates to vote in each local government area, in each constituency, were selected by people, and those delegates elected the members of the Constituent Assembly. In my own case, my constituency covered Okpe local government, which at that time included Sapele, Ubie, Udu, part of it. I was returned unopposed. That was what I had. Etiopnot was represented by one Mr. Amon Chifesi. So that is the way that no matter when. There was no contest for me to be Constituent Assembly. I was returned unopposed.
Unopposed.
So that was the one I did. And again, in that place, I worked hard.
Hmm. There is it cannot be argued. The facts are there. Um,
I worked on the constitution at two levels.
okay.
We worked in 1988, 89. 1988 produced the 1988 version of the Constitution. We submitted it. The intrigues that we saw, in fact, led me to a suggestion that all this one we are making, are they going to be workable? Why don't we invite Germany and lease this country to Germany or to Japan to manage for us for 50 years? Then the rich richer, the poor more comfortable. They said that you are not being realistic. Okay, here we are. We have got it. People are not reading and understanding the Constitution. Anyway, finally, it was not published. It was not subject to referendum and so on. Then when I became president of the bar, I was now put into the CDCC, Constitution Debating.
And that was when?
That was 1998, 1999.
Yeah.
So what was it? We had to review the 1989 Constitution plus other suggestions and formulated the final one that in the 1999 Constitution. This is how far I have gone in continuum making, but nobody knows.
Of that, you see, that's why this interview is very, very important, because a lot of people don't know. They tend to assume, they don't even know that a lot of these things you can sit down to educate them, but you are this kind of quiet person. You don't really make noise as such, and because of that, sometimes when they are making noise around and you are there, they don't know that even right there you have Abuja right in your palms. Is something that
We were the first people in Abuja for the 1971 review of the Constitution, 1999 review of the Constitution.
can imagine.
We were there. What was our pay? 16,000.
16,000
I left
naira
my practice to go and do 60,000 job for the country.
for
because I
nation
love the
building.
country. I have no other country in this world. And let me tell you one small secret. I have traveled extensively across the globe. I've never seen a place
Like Nigeria.
that's number one. That is the one I can call my own.
Yes.
And each time I go to the UK, that's the place that I can stay longer. First 3 days, I sleep very, very well. I pay all the arrears of sleep that I have missed in Nigeria. The next 3 days, I sleep normally. After the 7th day,
You think about coming back home.
I want to come back. Everybody who's around me knows that is the pattern. I hardly stay more than 10 days
Wow.
outside the country.
That's interesting. Now, away from politics, now we want to go to law. The name Chief Thompson Onombo Joseph Okpoko OONSANFCI associated with plea bargaining in Nigeria. We want you to tell us your experience about it.
Okay. Well, I can say it now. My client was the governor of Bayelsa State, whose election petition I did, so kept me on thereafter. Chief Alamese, When the crisis came, and those who wanted him out of power set upon him and arrested him and took him to Force in Ikoyi, I think number 15 in Ikoyi, Awolowo Road in Ikoyi. He again contacted me to intervene and provide him with service. I went in, I saw him. I can hardly allow you to see him, but I saw him when they knew that I was a lawyer. I discussed with him many times over a long period. They have charged him to court. I have gone to court. I didn't want any noise. I wanted him quietly to resolve the issue. Not by compromise, not by bribing and all that. No, that one was not coming to it at all. Then I went to the head of, I think it's El-Rufai, or who was it? I don't know what it's El-Rufai, who was the first chairman or something like that.
Ribadu, no Ribadu.
No Ribadu. Ribadu was not, I don't know whether it's the first. Is it the first?
Well, I think no Ribadu. No, Magu is, I think, later.
Yes.
I think it should be no Ribadu.
Yes. But I spoke to the people in the legal department, investigation department, who didn't matter. So I told them, I said, look, you want to kill this man is not well. They have tried to drag him down much earlier, when one man from Bayelsa brought action in Lagos, say, without serving him, brought action against the chief of staff because he was a member of the government. And judgment was given in his favor. I went there, took the matter up.
Okay, you did that case.
I did that case. Then ultimately, the Court of Appeal set aside the thing. Those people were still after him. They were part of the people who were prosecuting him. They only handed him over to the authorities to do something about it. So I told them that, look, all these many charges you brought, you know there will be confusion in the proof for these charges. Why don't we make a plea bargain? They said, no, can never do a plea bargain. I said, what? Then they asked me, what is a plea bargain? I said, it is known all over jurisprudence that no country can prosecute every crime committed in that country. It's not possible. Therefore, you look at the category of crime. If it's the one that took life, maybe you cannot again. But any non-capital offense, you can say, look, gentlemen, these are the charges we have against you. Tell us the one you will admit. Tell us the consequences of what or those you won't admit. And then we can strike a compromise for you to plead guilty to the ones you admit. And we will not proceed with the ones you do not admit. That is the basis of the plea bargain. That is practiced in all parts of the world. Unfortunately, our prosecuting system here did not quite recognize it at that time. So it's somehow very strict with them. At the end, they also look at it. Magu, I think the last chairman.
The last one.
Yes.
That should be Magu.
Magu was one of those who looked into it. They
Yes.
have lawyers, I've forgotten their names now, who looked into it and said, yes, it is possible. Then we sat down to negotiate. Of these counts, this account connected with property, with this, with this, with this, and this. Said, I'm prepared to tell my client to leave all these properties for you to forfeit. But leave him with this one where we stay in Port Harcourt. Leave him with one in Abuja. And leave him with one with some in Yenagua. Yeah. Take whatever is left, including the one in London. That was what we did. This country gained from what is surrendered to them, so that they will not prosecute him for those properties, at the towns that concern properties. We didn't allow anyone to take it into their private pockets. They forfeited to the government. Then the ones where they started with not disclosing the account of his children. I said, okay, this is a failure not to disclose the account. Plead guilty to this one. At the beginning, he was hesitant. He said, no, I cannot plead guilty. I have a political future. I said, yes. Which one do you want? To die in cell or be convicted? He said, think about it overnight. I'm coming back tomorrow. So I went to him next day and said, look, that's the position. He said, well, I'll take your advice. That was how the matter was taken to court. We pleaded guilty. He pleaded guilty to those 5 counts of not disclosing the account, 4 counts of not disclosing the account of his children. And the state now said, okay, in view of your plea, we will not pursue these other cases. In law, that's duty for these cases. That was how plea bargain came to be recognized, although it has long existed under
in other climes. What this revelation simply means is that I think it's safe to say that you played a major role in the legalization of criminal mediation in Nigeria, because plea bargain, or plea bargain as it were, is part of criminal mediation. So you played a major role. But why is it that a lot of lawyers still don't understand this whole thing? Is there something that it appears there are some strategies, some secrets, some things they actually don't know. So they don't want to go there so that they are not caught.
Well,
Uh,
the
the wrong
position,
way.
it depends upon how you do it. You either do it honestly or you do it dishonestly. If you want to do it honestly, follow what I have just explained. Go to the police, go to the prosecuting authorities and say, look, my client is prepared to admit this one.
Yes.
These ones, it's not going to admit them. Do we fight or do we resolve it? That's criminal plea bargaining.
Yes, criminal,
That is what it is.
of course, criminal mediation.
So you ask why our lawyers
Mm.
are not understanding or not showing that they understand what plea bargaining is. Again, it is like a state of the mind. For every plea bargain case you do, you've terminated the case. Supposing you are not satisfied with the money that your client is paying you. So, because by doing that one, you will not forget money that of each of those cases that will not be prosecuted. I don't know whether that is the reason, but I think every country must recognize that it is not possible to prosecute every crime that is committed in the country. Otherwise, let us go and stand by the road there. You will see crimes
Every day.
People are driving against the road. People are crossing the road by foot when they should not. But there's no zebra crossing. All the crimes. Are you going to prosecute all those?
Not at all. is very, very, very interesting to know this. So, Chief Sir, further, we we observe that there have been some drawbacks concerning the administration of criminal justice law in Nigeria, the administration of criminal justice system in Nigeria. Uh, I don't know if you can tie it to this issue of no case submission and to say, okay, that's part of the problem. Or if there's, do you have, which other drawbacks you have noticed?
Okay. Unfortunately, the Administration of Criminal Justice Act seems to have been an enactment based on the advice of theoreticians or people who do not properly pay attention to the reality. There's difference between vision, expectation, and reality.
Expectation and reality.
So we have to look at it not only from the vision point of view, not only from the speculative view, not, not only from the academic point of view, but what is reality on the ground. The common law recognizes, and our constitution recognizes, that every citizen is presumed to be innocent until the contrary is proved. And to prove the guilt, to prove that the citizen is guilty, you must do so beyond
reasonable doubt.
As to what constitutes beyond reasonable doubt, that's a matter of interpretation. But the provision is that it is clear that the standard of proof in criminal cases is higher than that of proof in civil cases.
The problems of it.
Yes. So you go to a criminal trial on that basis that your client is presumed innocent. Then the prosecution to prove his guilt beyond reasonable doubt. In the process, they call their witness. The accused person's counsel or accused person himself cross-examine either to destroy the case for the prosecution or advance his own defense. That is the position we take. So there's a tangle at that stage. If at the point when the prosecution say this is the case for the prosecution, that means they call all their witnesses. The accused person is entitled to say at that stage that there's no need to ask me to go for trial because the evidence you have produced so far is not warranted. So that is what they say in that case. In that case, you make a no case submission.
No case submission.
Basically, on the ground, the evidence before the court. Essential ingredients of the offense
are not present.
Or the case for the prosecution has been so destroyed in cross-examination that no reasonable tribunal will convict. All that on the whole, as it is, the accused cannot be guilty, or there's no nexus between the accused and the offense. If you succeed in convincing the judge in that way, then your case, your client will go away, discharged, and acquitted. So if they arrest him again for any of these offenses, you can say, well, I haven't acquitted before, so it's a permanent defense. That is that one. What is the position? Then that's one. Apart from that one that follows a trial, there is a further point arising from the presumption of the common law and the Constitution saying that everyone is presumed to be innocent. In my early days in practice, if you want to charge a person to the High Court, you must first go to the magistrate court and do what they call preliminary investigation. If at the end of preliminary investigation, when the prosecution will call all their witnesses, the judge will have to evaluate. The magistrate will have to evaluate at that stage whether they have satisfied the requirement for conviction or for a requirement for trial. And that will involve them looking at the evidence that has been given so far. If it does not satisfy them, then they will discharge the accused person upon the submission that no prima facie case is established. People tend to confuse the two, but yes, they are different. If the lawyer says, well, look at the evidence that you have produced, it is not sufficient to prove the case beyond reasonable doubt. If the magistrate is satisfied, then that case goes away. It does not go for trial. So these are the three scenarios. But there was one other one. Even when the case, the other one that they do, where there's no PI, no preliminary investigation, which they don't do nowadays, you file a motion or you file information with the leave of the chief judge of the state. The chief judge of the state normally will not just have the time to read the bulky thing that you file. So if your affidavit evidence shows why you are filing, what you are alleging, and so on and so forth, then it will grant you leave to file information against the accused person. You now file your information. Information is served to get all the particulars on the accused. The accused goes to his lawyer. His lawyer takes up the brief and reads the information on the attached documents properly. If the lawyer comes to the conclusion that there is no case against his client, he applies to court, say, dismiss this information without trial because it is an abuse of the process of courts. You can't charge a person when you have no evidence, and so on and so forth. That was the thing that used to happen. And there are series of cases. One of the best known of them is the case of Ikomi, a judge who was alleged to have killed his ugly, or something like that in Benin. At the end, when the case was taken to court, Supreme Court took the view that he ought not to have been charged in the first place because the information does not disclose case against him. That was the position. Then, in Abacha's case, it was the same. Abacha. Take the son of Abacha, not Abacha himself. So that was the thing. Now that was the basis upon which these cases were resolved. So what we have gone through here now,
yes, sir.
No case submission after the evidence of the prosecution. No prima facie case following investigation. That is the thing. And then the third one, where the indictment is quashed on the ground that there is no evidence. The makers of the Administration of Justice,
Administration of Criminal Justice Act.
yes,
Law
Administration
as
of
the case
Criminal
may be.
Justice Act did not seem to have captured the third scenario. That is, that the information must be quashed on the ground that it does not disclose
The case.
That one does not disclose, does not require any enactment. That principle requires no enactment. Because its root is in the common law, is in the constitution and the common law. But here, instead of making it clear, some judges are interpreting it as if that third arm does not exist. Let me take you to section. Section 301. This section 300 subsection 1 said, after a plea of not guilty has been taken and no plea has been made, the prosecutor may open the case against the defendant, stating shortly by what evidence he expects to prove the guilt of the accused person. The significant word here, after a plea of not guilty has been taken, then you go on to prosecute. What a party for objection is raised before a plea is taken. That would have made the scenario of watching the judgment on the ground of an abuse. Some judges have not taken it upon themselves to say, no, once the plea has been taken, then I must take it to the conclusion whether the person likes it, whether there's evidence or no evidence, the person must be tried.
That's a waste of.
That is in an attempt to do things in a hurry. I think that is even in one of the sections here. I have not quite got this one. They say if you raise an objection, then the court can say, okay, because you are not decided, but you shall wait until the end of the case. That is a violation of the Constitution.
Yes.
The Constitution cannot say I'm presumed to be innocent. You produce junks as evidence against me. Evidence does not incriminate me. Then I raise objection. You say, no, I should wait until the whole unnecessary evidence has been brought in. That is a very fundamental issue that has not yet been resolved under this law. One day, we are hoping that we'll have the opportunity
to test it,
to come and resolve that issue. There is a lot in the Administration of Criminal Justice Act that were put there because they said, oh, trials are too slow. These ones are too slow. There are other ways of making trials to be easy instead of this type of provision that tended to undermine the fundamental principle that has existed in England from the beginning and up to Nigeria under our constitution. If I'm presumed to be innocent, why should I go on for trial at the discretion of the judge? No, not even at the common. The judge takes the view that I must go for trial because there's a case, there's an indictment.
Just like a speculative evidence, yes. No evidence.
Have you made up your mind? So, and this is the type of thing that causes injustice under this Administration of Justice Act.
So, in a bid to come up with a law such as this Administration of Criminal Justice Act or law, as the case may be, in a bid to solve the problem in the criminal justice administration system, they ended up compounding the problem
and confusing judges who are not prepared to research and work. You cannot have the background of cases like Komi, like Abacha's case, and move to say, I will go on with the case. Even the section 300 subsection 1 refers to the position after a plea has been taken or a plea not taken. Right? If a person is of, is not of, if he has taken a plea and you do not guilty and he has pleaded, yes, you can then go on. That means he's putting himself off for trial. But if before the plea is taken, an objection is raised that the facts available do not warrant the prosecution, then that's a different scenario.
Yes,
You cannot equate it with this one.
of course.
Or the case where a little child or something like that one, or somebody of mental capacity or so on is brought. And of course, he cannot take a plea because he won't understand what is going on. Those ones are different from where the man has his proper faculty, he knows his right, his lawyer knows, and he says, I submit that there is no point in putting my client on trial because he's presumed innocent. Innocent because look at the case you presented on the paper. Nothing affects him. So these are the type of things that we need to go back, look at this one. As for making the trial fast, again, what happened if the prosecution put forward this case? The provision for pre-trial conference can do a lot.
Proper case management.
Yes. So if the judges are prepared to conduct pre-trial conference and the lawyers are amenable to that type of thing, then you will find that it will not take more than 2 days to finish a whole case because it doesn't make sense. You look at it. A man is not arguing that he has the account. You want to go and bring the bank manager to come and tell the court that that's the account. Whereas at a pre-trial, you say, look, this is the evidence before us. This is what is here. The kernel of this charge is that you took this money. Yes or no? So I did not take it. Okay, go for trial. But if the man says, I took it, but I have a reason for taking it. Okay, so make it there. Your reason, your trial at the prosecution, the reason for prosecuting him will then be limited to not the question. It will not cover taking or not taking it. It will not go to the question of justification for taking it. That can cut short the time. But people are not willing to work hard or to follow the rules of plea bargaining and or pre-trial conferences. What we need most now is pre-trial conferences.
So for proper case management.
Proper case management.
Okay, sir. I think this one is very revealing. We have Emmanuel Uti, who is also watching here. You have Gospel Roga. You have Ogenero, and a couple of other persons watching us live on the online. Not here. You have members of the office watching by Zoom.
Are they watching?
Yes, they are watching. We're streaming it live. They are watching. There are a couple of persons beyond. They're watching it. So you can send a link.
They are working on the build, so they can't.
Okay, Chief sir. So let us take it further. In fact, this is more than a law school, because this is actually what we need. We need to get the gist from you people direct. But when we say the law teachers, you are the people that are actually teaching us, taking us through the rudiments of what practice should be. Chief, sir, in the light of is a COVID-19 problems and what have you, we now have new ways of practicing law. And one of such is that which is supported by this virtual law practice. Um, we want to know your thought about virtual law practice. If it is such an idea that you are very much in support of.
Well, legal law practice, I have not been involved in any one of such cases. But if the facilities that we have
There.
in our courts, in our offices are adequate, then it could, but not wholly.
Yes.
Visual practice of taking the evidence of the witness will rob the court and the judge and the other party so many things. So if we're going to do visual listing, we should start gradually.
It's a gradual process.
Yes. You can take motions,
Yeah.
no matter how controversial, because the meaning of the witness is not established.
Yes.
You can take motions. You can take judgments by visual practice.
Yes.
But the core manner of giving evidence will still be necessary for the parties to be in court, for the witnesses to be examined. Witness statements are helpful, but from what I have seen, from what I've gone through in so many cases, it may still be necessary to cross-examine face-to-face witness.
Different from
Yes,
virtual
especially,
cross-examination.
especially in a society like Nigeria, where people deny
Yes.
and insist on falsehood.
Yes.
So it may be necessary to get the witness to be on the witness box and cross-examine him to know the extent of his knowledge.
Yes.
I think visual court proceeding to cover the calling of witnesses.
Okay. I think the NJC directives of May 2020 also talked about it for motions, non-contentious cases, and what have you. And gradually, it could be incorporated in hearings
Yes.
when the parties do agree.
Mhm.
We already have two rulings on it in Delta State. Rulings handed down by Justice Okulusi on virtual one is on virtual witness deposition on oath, and the other one is on virtual service of the originating processes by the WhatsApp contact.
How would they do virtual witness statement?
Yeah, this one, the virtual witness deposition on oath, is such that is done um, via WhatsApp, just like as we are here now. The We use the Zoom facility, the Zoom everything. You take the the facility down there to the court, so the witness is somewhere in Lagos or maybe somewhere.
Okay, a witness giving evidence on this.
Yeah, so
Then he must have submitted his witness statement.
yes, submitted the witness, transmitted by PDF format.
Yes.
Yes.
So it is cross-examination now.
So yes, so it will now be cross-examination. So for instance, if we have documentary, if the case is more or less a case that is based on documentary evidence, will it not be ideal that we still have cross-examination by virtue, since it's more of documentary evidence?
It may help. It may help. All that I'm saying is that judicial proceedings, yes, but let us tread
With caution.
If we don't tread with caution, we will somersault.
Yes, we may abuse it.
We may somersault.
Yeah.
In our society where abusing a process
Yes,
is the order of the day.
Very instructive. But that is actually one thing that's one takeaway here, because before you said that we have a society which is different from what you have up there, and here people they depend on falsehood. Yes. They stick to it, so it will be difficult for us to rely on it fully here. We need face-to-face cross-examination to understand, to observe, to study the demeanor of the witness. Based on your background as your as a teacher, when you talk about child psychology, I already knew where you were going in the area of
looking at the person.
Yes, looking at the person, because that is a part of education. It's an aspect of educational psychology, cross-examination. So it's something. Something that one has got to learn from. She's like, okay, now let us move down home. Now you have a robust partnership in your law firm, and one of the strongest in this part of the country, if not in the country, but in this part of the country, one of the strongest. When we say robust partnership, a partnership that thrives even without you there. It's there. It's just like there is rare. You can only find such kind of partnerships in the developed climes. But here in Nigeria, we have someone like you, in, very much, who has, do we say, you have brought it to bear. You have made people to know that these things are actually possible. Okay. I want you to tell us something about it.
Well, I have taken a view from the very day one when we were in the law school that law has to be practiced as a business.
Okay.
And that the era of one-man show is over. So in the law school, we propose and agree and let Scott Marple, Christian Scott Marple, may his soul rest in peace.
Amen.
Then he arrived to Warri 2 days before me because I was waiting for my wife to come from England to hear me before we come. So when I came home that same day, I went to look for his office in Daoud. There I saw him. He was already there. And I said, okay, how do we start? Do I report for work tomorrow? And he said, no, that I can see that it's already established. His office furnished. He has a car, has a equipment. So he does not think that partnership is necessary again. I said, okay, well, let me go home and roughing it up. So, fortunately for me, in the evening of the day I arrived, that Saturday, somebody came to me that a man stole a bicycle from a village near my own town. So on Monday, I had to go to court. I came on Saturday. Sunday, I had the brief. Monday, I went to court. He stole a bicycle. Police investigated. They arrested him, and he took them to where he hid the bicycle, and they recovered the bicycle. So I told him that, well, I will go and plead and the accused was forgiven. Otherwise, we have no defense. Understanding, he called the case, and I said, Your Worship, my client will admit that he stole the bicycle. Everybody was looking at me. How? I said, my client will plead guilty. And so when the case was called, everybody was looking, pleaded guilty. Then I pleaded for him that is just poor village man who has nothing. I should cost million to us. At the end, the court said, Mr. Coco, thank you very much for what you have said. If I find your client guilty on his plea, I will, because of your allocators, I will fine him £3. To fine him £3. His relations who came were happy. They just took the £3, paid down. Everybody jubilated at home with their man. That was the opening chapter of practice. Then, of course, one of our classmates, Mr. Opewono, Alucius Opewono, he now came to meet me. He also had nobody, so two of us joined in this partnership. Small thing we have, we share from the Brede, which is Isoko, in Undokwa.
Yes.
Isoko community in Undokwa.
Yes.
And that his people came to him, that they have nobody in government, they ask the government to give them a chance to produce somebody. And the government has agreed. So they came to him to go and be a PPO state council.
Mm.
And he nearly cried. He himself nearly cried too. At the end, he had to go to Benin to resume in January 72 as a PPO state council.
Mm.
So 1st February 82, PPO state council. From that one, I didn't have a partner again. Then I took on Emmanuel Delipe. His Royal Majesty Emmanuel Delipe, the OV of Ubu.
Okay, the current.
Current OV of Ubu.
Ah, wow.
Took him at 1973 or 74.
Wow.
So he worked with me. Then later, Chief Jesa joined me. Jesa was my classmate in the UK, but I left him there. So he came years later and joined me in 1960s, 76. Dedeke was with me.
I wasn't born then.
Dedeke was with me. When Jesa came, I told Jesa, we were classmates, I cannot make you a salary solicitor. Instead, let's rough it out as partners. So I offered it to him, and I think he's the luckiest man in this world who got partnership as his first assignment as a lawyer.
Hmm.
But my faith in partnership has never gone down. Then I said, well, Delepe has been with me for the last 3 years. You have just come. I cannot make the remain where he was. So I invited him to become a partner. We discussed the terms. Next day, he came to me that he discussed with his people, and people told him that the terms I was offering him was not good enough. He was to get 35% of the gross earnings of the office, 35 or 25. Jesa was to get 30 because he's a senior to me. Yeah, that was it. And,
Very, very interesting.
he then resigned and left. That's why. Then Jesa was with me. We were the only two partners when I went to the Constituent Assembly. But we had juniors whom were grooming for partnership. He told me, well, in the year through far away, if I know for GC Arubayi, Charles Ajuya,
Yes.
and Jennifer Muro, who were the people who were with us. I went to the Constituent Assembly in 1988, and as a result of my experience in
Politics.
that was sort of not the political side, but my office, because I was still coming home every weekend
Wow.
to go to court. We don't sit on Fridays, so my kids are adjourned to
Fridays.
And I come to do them. I do 1 week in Lagos, 1 week in Warri.
Wow.
So that I was traveling every time. But I found that the office was not a good stead. So when I came back, I said, okay, let us expand the partnership. Finally, we agreed and admitted 7 partners. That's where we have been all this time. And others will groom coming. Now, my thinking was that, look, when you brief the firm of Thompson Okoko and Partners, you are briefing not only Chief Okoko, you are briefing every lawyer in the firm. And this visual thing has made it easier for us.
Yes.
We take instructions, whether in Lagos, Port Harcourt, Abuja, Warri, take instructions. It's immediately spread to our offices.
Yes.
They all work on it and report to base. The base here now people here coordinate it. If Lagos is the base for that one, Lagos coordinates it, and so on. We look at it. I have never believed that one person alone should form a firm. No, that's not the business. But somebody, the man is sick, or he was involved in an accident.
It's gone.
So somebody should be able to stand in when another one is stepping out. That's where we are now.
That's very interesting.
We do not earn the money that other people earn, but whatever we earn, we share for ourselves. Subject to our paying our salary solicitor, who in due course will also be elevated to this place, depending upon their hard work and dedication. So that's the way we have seen it, and I think everyone in the office sees it that way. And so we are.
Is because it's actually difficult to find anybody who has actually passed through you, who is actually strong.
But I must tell you that it's not an easy journey. You have to trust. You have to be honest.
Integrity.
You have to be strict to tell whoever is transgressor, this is what you've done wrong. This is what you've done wrong. You have not done this.
To take you back a bit, there's this aspect, this because from what those who are not close to you, like for me, I was teaching at a Scholars Academy.
Mm-hmm.
I taught here for years before I went to study law, and I could hear much about you, and so every time I walk past this place, I'll say, "Ah, I'd like to work with you." When I graduated, but coincidentally, when I graduated, you were even the person that did my introduction
Okay.
before Justice Masham Mukoro.
Okay.
And though I started working with AK Osawata as an associate, not a paid staff. I've never been a paid staff. And from there, I said, okay, since I just said, let me go and pair up with SM Duku, who happened to be a pastor. I said I wanted to practice law as a Christian because I was afraid. When I hear lawyers, people talk about lie, lie, lie. You have to lie. You have to lie to clients, lie in affidavit and all that. But when I look at you, look at this interview now, what you said about plea bargaining, because when you are evaluating the personality of someone, you should be able to tell what that person stands for. You talked about plea bargaining in one case.